and I don't think I can add much of value to that discussion. I will do what the moderator has asked me. Having had the extreme privilege, I would say, of being at one time the sole junior to both Sayyid Ishtiaq Ahmed and Mahmood Islam. It is my honor and my privilege to be here to speak at this program being held in the blessed memory of my late senior Sayyid Ishtiaq Ahmed. And it is a privilege to also be on the stage with the Honorable Chief Justice. I have spent many hours in our chambers trying to decipher his most beautiful but almost illegible handwriting. I actually obtained a magnifying glass to do so. And also with the learned Attorney General, we've spent a lot of time together in chambers. A personal anecdote. I came back after being called to the bar in July of 1989, and within 1 or 2 days of coming back to Dhaka, my father called me and said to me in exactly this language, "Car chamber join Korbi." And the picture which flashed in front of my eyes at that moment was of a tall, genial, smiling gentleman wearing a crisp white kurta pajama, carrying a polished silver box full of pan and shupari in his hand. And it didn't take me more than half a second to say that I would like to join the chambers of Sayyid Ishtiaq Ahmed. My father immediately called him, and you remember those telephones you could hear. So he said, "Je bhai, main to apnar chamber join korte jacche." And I could hear him saying, "Kalke shokale kote pathiye diyen." So next morning, young me, never come to the court before, I was decanted in the Bar Association building. And it so happened that that was the day the judgment in the 8th Amendment case was delivered. And that is the day when I first came to court. The keynote speaker, and I must compliment him on a very well-written paper, has said that the collaboration between Sayyid Ishtiaq Ahmed and Mahmood Islam culminated in the landmark 8th Amendment case in 1989, which established the principle of constitutional supremacy for the first time in our history. I was then made to make a list of all the case references in that judgment by hand. I can assure you it was not a very easy task, it took a long time. But it was in this case that my late senior identified and established as the pole star of the Constitution, Article 7.1, that all powers in the Republic belong to the people and their exercise on behalf of the people shall be effected only under and by the authority of this Constitution. So who is the guardian of the Constitution in this country? It is the Supreme Court. And it is, under this supervision, it is also the rest of the judiciary. As we have heard recently, there is again an issue which has arisen. Discussions are being held about having permanent benches of the High Court Division in various parts of the country. This was very much the crux of the case in the 8th Amendment case. We will need to think very carefully about whether we want to remove the pole star from our Constitution. The Constitution is not a divine document. It is made by people, for people. It can be amended. But we need to ask ourselves whether, as a nation, as a society, we want to remove the center and allow all the parts to dissipate and perhaps not be conducive to the goal of delivering justice to all citizens who are equal before law and to provide equal protection of law to everyone. I remember my late senior telling me that when the caretaker government in 2001 stood ready to give effect to the separation of the judiciary from the executive, the then Prime Minister-elect, not the incumbent Prime Minister, the Prime Minister-elect called him and requested that this be put on hold, as she would like to be the one to do it. Today we are in 2025. The sun is charging ahead with every resource in his command to finish the task. But there are strongly vested interests who would seek to delay what has to be inevitable in the nation's life. We have waited 53 years for it. I hope we will not have to wait another 53 years. Now let me look at this issue very quickly from another point of view. Why do we want this separation so desperately? It is because the rule of law stands against the absolute power of the states. While the rule of law is the most important guarantor of democracy, the sine qua non for rule of law is a strong, independent, and ethically unimpeachable judiciary. I may have every right available to man or woman written into the books, but when I am deprived of them, who do I go to? As a citizen, should I have to beg from door to door, from politicians, from the executive? No, I will go to the court, which is the guarantor of my rights. Historically, and let me go back quite a few centuries, when the British East India Company started expanding its territories in India, they created the position of district collector, and that was formally established in the late 18th century. The primary responsibility was revenue collection. But as the British consolidated their power, the role expanded to include law and order and implementation of government policies. It was initially created by Lord Cornwallis in 1793. Beyond revenue collection, the district collector played a pivotal role in maintaining law and order within the district. The responsibility included overseeing the police force, ensuring the smooth functioning of the judicial system, and implementing measures to prevent crime and civil unrest. The district collector acted as the chief magistrate of the district, holding the authority to make judicial decisions on various civil and criminal matters. This dual role, is a colonial construct. We are an independent country. Therefore, this duality cannot remain. Magistracy and executive power, when bifurcated, it took a long time to achieve even basic separation in our psyche, in our minds. So who has the biggest interest in seeing that this bifurcation doesn't take place? Those whose actions are such that they should be accountable to us, the citizens. The executive power. So even today, the executive, whose actions would be the subject of judicial scrutiny, obviously are not very keen on having this bifurcation. This is reflected in the continuous delays in setting up the Secretariat, the Independent Secretariat for the Supreme Court. Otherwise, should a government wish to do this, it will take not more than perhaps a month to get it done. And I see absolutely no reason whatsoever that in today's dispensation, post the July uprising, given this government, that there will still be interest in the highest policy-making levels of government not getting this done. Going back to the Masar Hussain case, what the appellate division did not endorse in the end, by senior's arguments, let me remind you, and Ms. Praveen Yogi has mentioned this, the Honorable Justices in the High Court bench, High Court Division bench which had the case, had decidingly endorsed. So I just want to read from the High Court Division's judgment. This is Mr. Mohammed Muzammil Haq J, as he then was. It is declared that in order to give effect to carry out and implement fully the separation of judiciary from the executive organ of the state, no constitutional amendment will be necessary, as the provisions for such separation are there in the Constitution itself. Then he goes on to say, it is directed that the respondents, number 1 to and 4, shall take immediate steps to make necessary rules under Article 115, etc., etc., and let a copy of this judgment be sent to the Honorable Prime Minister of Bangladesh. It was a resounding order. In this connection, the puisne judge, Justice Muhammad Hassan Amin, his observations have been quoted by Pravida, and I will not go into that, but what 2 things he said. Quote, "By this time, long quarter century has passed and much water has flown through the rivers of the country like Padma, Meghna and Jamuna. And as such, it is high time for the authority to give recognition to the separate identity of the Judicial Service of Bangladesh by making rules in view of the distinct nature of duties that a judge is called upon to discharge." And then he goes on to say, "Independence of judiciary cannot be secured by making mere solemn proclamation about it. It has to be ensured both in substance and in practice. The society has a stake in ensuring independence of the judiciary, and no price is too heavy to secure it." So this is the legacy that we are dealing with at the moment. The clock seems to have turned almost full circle. My Lord Chief Justice is here, and what I would like to finish by saying is this, that we have had hope that this will happen many times before. We have hope now. My learned senior and I used to share a great love for cricket. So a few years ago, I was in Dhaka Stadium, and people were singing. I think Bangladesh team was in trouble as usual. People were singing, "Amra korbo jai ekdin," in a very sort of low voice. "We will overcome one day." আমি খুব বিরক্ত হয়ে বললাম যে আমরা করব জয় একদিন কেন, আজকে করলে অসুবিধাটা কোথায়? With many thanks to all of you for having attended this first program by the Ishtiaq Center, and I hope we will be able to provide intellectual, not just intellectual matter for intellectual thought to you, but also the impetus to actually make progress in these matters which are central to the life, liberty and expectations of our nation. Thank you very much.